Yes, Lord Wolfson.
My lords, my lady, I appear, as the court knows, with Mr. Callis and Ms. Walker Parr for the appellant, my learned friend, Ms. Evans, King's Counsel, and Mr. Silverstone appear for the respondent. The court will have heard, I think, that there are a couple of pieces of housekeeping.
Yes.
The first relates to the transcript issue. The short point is this. Under Section 9 of the Contempt of Court Act, we need formally the court's permission for the transcribers to record the proceedings. We have transcribers, instead of sitting in court and listening orally or using the court's recording, they want to use the recording from the court feed, the YouTube feed. They are official transcribers. We have, I'm instructed, filled in the relevant forms. I understand that, I'm afraid, they haven't reached my lords and my lady, but we seek formal permission. There is a note in the White Book which says you can't assume that permission's been granted unless you ask for it and get it.
Is there any fee that's required?
I don't think there is. No. I mean, what I can say is that if there is, I undertake that we'll pay it. But I don't think there is. They're called just for the note. They're called Epic. That's the name of the transcribers rather than the quality of my submissions. And we seek formal permission. Yes.
Yes, we grant that permission.
I'm very grateful. The second point of housekeeping, just to check we have everything. This is a case where everything is in twos, if I can put it that way. We have two bundles, core and supplementary. We have two bundles of authorities. We also have, of course, two skeleton arguments, which yes. I apprehend the court will have read.
Lord Wolfson, I noticed that with the authorities, that the respondent supplementary authorities bundle says in parentheses, not agreed by appellant.
All that means is that we haven't formally agreed that, so to speak, there should be a supplemental bundle. I'm not taking any point on it. The learned friend can refer, of course, to anything she wishes to. I'm not seeking to put any procedural obstacles in anybody's way.
Right. Thank you very much.
Can I therefore begin with a few remarks which I hope will set the scene for my submissions and will indicate to the court the structure which I would like to adopt. First, there is no challenge whatsoever to Mr. Justice Chamberlain's findings of fact of dishonesty. On the evidence before him, the learned judge was entitled to take that view of my client's case on the overseas conferences. Of course, the court won't be surprised to hear that with the greatest respect, my client doesn't agree, of course, with the learned judge's conclusions, but we are not challenging them in any way. So there is no challenge to any findings of fact on this appeal, nor, frankly, could there be. Therefore, we proceed on the basis that the litigation misconduct, and I'm going to use that phrase, which I hope is a useful phrase. We all know what we're talking about, i.e. the plea of disinvitation from the overseas conferences as part of the alleged serious harm, that the judge's finding of dishonesty stands, albeit, of course, that plea was superfluous in the sense that it had been dropped before the trial, and of course my client still won on serious harm. But that's the background. There are a number of facts which are not in dispute for the purposes of today, and again, let me set them out briefly. First, my client claimed in respect of 15 publications, each effectively alleging a specific fraud at Chase Level 1, namely that my client had fraudulently claimed to be Satoshi Nakamoto, the inventor of Bitcoin. Publication 12 was slightly different. That was that my client had fraudulently claimed to be the author of the Bitcoin white paper, but not much turns on that. Publication 16 made the same allegation at Chase Level 3. Second, there were originally some positive defences run in defence of the claim. Truth was run, public interest was run, and importantly, abuse of process was run. All these were dropped by the defendant long prior to the PTR before Mr. Justice Julian Knowles. Much of the respondent's case, even on serious harm, was struck out at the PTR, and an appeal was refused by my Lord Justice Warby against that decision because it offended against long-standing rules about the mitigation of damage and the pleading of prior bad reputation. Third, that meant that by the time of the trial, there was no substantive defence being run at all. The liability issues at trial were therefore these. meaning, liability for publication of publication 16, and serious harm. All three were resolved in my client's favour, notwithstanding, as I've said, the judge's finding that a previously relied on aspect of the serious harm plea, i.e. the overseas conferences, was found to be dishonestly advanced. And so my client was the winner on all of the issues before the learned judge. He won on meaning, he won on serious harm, and this in respect of 15 publications, all but one alleging a specific fraud, 15 at Chase Level 1 and another one at Chase Level 3. Fourth, as the court will have seen, the claim form limited recovery across the publications to £100,000 in damages. However, and of course this is why we're here, the learned judge awarded my client just £1 in nominal damages. But not only that, as the court will have seen, the learned judge awarded my client no other relief at all. At a later hearing, he refused my client an injunction or to accept an undertaking, and permission to appeal against those decisions was refused again by my Lord Justice Warby. And again, for the purposes of today, that's the end of it. I'm not going to go back to that substantively, but it's part of the background. The other part of the background is that when it came to costs, my client was required to pay 100% of the reserved and outstanding costs and to pay them on the indemnity basis. So against that background, 2 points jump out in my respectful submission. First, this is a claimant who won at trial on meaning and serious harm where there were no other defences in respect of 15 publications of a Chase Level 1 specific fraud, and walks away with £1 in his pocket together with an order to pay the other side's costs on an indemnity basis. Secondly, and perhaps this really flows also from the first point I just made, this is not a case where the judgment can sensibly be said to be, or is, a vindication of my client's reputation in itself. You only have to read it to see that. Now, turning now to the substance of the appeal, and can I take a moment, if I may, to try to impose a little bit of focus and nomenclature on the definitions I'm going to try to use. I'm going to try to be at least internally consistent. The cases, with great respect, are not always internally consistent. I will try to be, and I apologise in advance if I'm not, but I'll do my best. When we get to damages, we have to, of course, appreciate that the law of defamation, like many other areas of law, of course has its own peculiarities, if I can put it that way. But like many areas of the law, it is not a freestanding area of law in itself. Every area of law needs to make sense in and of itself. But every area of law also needs to make sense and cohere to general principles of English law. There's a danger, if I can use the modern phrase, of thinking in silos. We see that in various cases which have come before the courts over the past few years. And the law of defamation, of course, belongs to the common law of tort, and general principles of tortious liability still apply. Having said that, of course, I accept that the law of damages in defamation is complex and perhaps a little unwieldy at times. There are statements of principle in the authorities which are not always easily reconcilable, if I can say so with respect. I'm not seeking today to provide a restatement of the law of defamation, but that is an important background for the point which I'm going to be submitting to the court. And that means that we do need to have some precision on 2 points. First of all, when we're discussing damages, what sort of damages are we discussing at any point? And secondly, what legal basis for reducing those damages or denying them entirely is being relied upon? It's against that background that clarity in nomenclature is required. And let me set out what I'm going to try to call for. General damages are damages at large for non-pecuniary harm. They are broadly compensatory, which in defamation they're designed to have the effect of vindicating the reputation of the claimant and providing solatium. I think in that respect I can use Latin even today. Special damages are damages which are pleaded separately, which compensate for specific pecuniary loss suffered by a claimant. Aggravated damages are usually given as an uplift on general damages for particular mental distress caused to the claimant by the defendant's conduct, often the defendant's otherwise legitimate conduct of the action to trial. So, for example, a failed but hopeless defence of truth run to trial is a fairly common example of a basis on which these damages are awarded. And in some cases, though not this one, where the defendant is a relevant publisher, i.e. a multi-author publication in the course of a business with editorial control, you can get aggravated damages under Section 39 of the Crime and Courts Act 2013. Finally, exemplary damages are penal in nature, available either at common law or under Sections 34 to 36 of the Act which I just mentioned. Now, this appeal only covers general damages, and that's really important for my submission. There was an aggravated damages plea in this case, but it was dropped just after the PTR. There was never a claim for special damages, nor any claim for exemplary damages. But we'll see references to those in the authorities, and that's why it's important to identify always what we're talking about. Now, I'm going to take a leaf out of Julius Caesar's book and divide my submissions into three parts. The first part is going to focus on the proposition that at common law, a claimant's litigation misconduct, including his dishonesty, is not a basis to diminish general damages in tort. There may be other adverse consequences for a claimant who misbehaves, some financial, some even criminal. As we'll see, the claim might be struck out even after trial, but reduction of general damages is not available. The only avenues to reduce general damages are those which fall within the broad restitutio ad integram principle. In the second part of my submissions, I am going to seek to review the familiar avenues for mitigating general damages in defamation actions and show how all of them in principle can be justified on the basis of the restitutio principle. Two of those avenues, conduct of the claimant and evidence properly before the court on another matter, have, we respectfully submit, in a couple of defamation cases, been allowed to stray outside the bounds of the restitutio principle. And the court will have seen that we take issue with the first instance decisions in Joseph and Spiller and Fly Me Now, which were the cases relied on in the present case by the learned judge, and also the decision of this court in Campbell and NDN, which the learned judge also quoted and relied on. That therefore leads me to the third point, which is if the court agrees with the analysis of the law which we're submitting, there's then a question whether this court is bound by its previous decision in Campbell and NGN. And we will be submitting that Campbell is not binding on this court, because although part of the ratio, the proposition that general damages could be reduced by litigation misconduct, which the court wrongly took, we respectfully submit, from Broom and Cassell, was never actually the subject of any argument. Alternatively, if it was the subject of argument, we submit the Campbell decision as inconsistent with the later decision of the Supreme Court in Summers and Fairclough, and to the extent that the Supreme Court didn't overrule it, the later decision of this court in Al-Haq. And therefore we rely on exceptions 1 or 2 in Young and Bristol Aeroplane. Finally, if we're wrong on all of those points as to precedent, and this court considered it's bound by Campbell, we respectfully ask the court, obviously the court would have to refuse the appeal, but we would respectfully ask the court, A, to consider giving permission to go to the Supreme Court, but also to give a reasoned judgment, because the court will have heard argument on the point, so the Supreme Court can have the benefit of this court's view on the substantive issues. But there I'm really straying into the complete discretion of the tribunal. So, my lord to my lady, let me turn then to the first part of our submissions, which is designed to establish that in the general run of tortious cases at common law, general damages are compensatory and cannot be diminished by reason of a claimant's litigation misconduct, even where that takes the form of dishonesty in exaggerating the claim. And I will take this, if I may, in 4 stages. Let me identify what they are. First, I will look at the restitutio principle as it applies to the sorts of torts that look to compensate for non-financial injury. Second, we'll look at 2 decisions, Al-Haq in this court, Summers and Fairclough in the Supreme Court, which establish in my submission that litigation misconduct can have many consequences, but not the reduction of general damages for tort. Third, the consequence, we say, of those first 2 points is that any legitimate avenues for mitigating general damages in tort can only be lawful and proper if they are in furtherance of the restitutio principle. And fourth, we'll look at how this principle can apply equally to defamation claims as it does, for example, to personal injury claims. So let me start with the restitutio principle in non-financial loss cases. At common law, of course, as this court knows very well, whether in contract or in tort, damages are intended to be compensatory. The claimant is meant to be put in a position as if the wrong hadn't been committed against him in tort, or in contract as if the contract had been performed. Of course, in most contractual claims and economic tort claims, where the only loss really is for special damages to compensate for ascertainable financial loss, this principle is pretty straightforward to apply. There may be arithmetical problems like discount rates, compound interest, but conceptually there's not an issue. The claimant comes along and says, I've suffered a loss of X pounds, and the court says we're going to compensate you by giving you damages of X pounds. Sometimes the present day value of X pounds, but we know what we're talking about. In other areas of the law, where the rights of natural rather than legal persons are an issue, it is harder to apply that principle to calculate general damages for non-pecuniary harm. And when I say harder, I mean both subjectively and generally more difficult. So examples might include the following: damages claims under the Human Rights Act, pain, suffering and loss of immunity, PSLA, for personal injury or clinical negligence claims. Of course, there are claims for the cost of care, lost wages, or special damages claims, but PSLA is different. Discrimination-related claims, including in employment law, vento bans, another example. Personality rights claims, including defamation and misuse of private personal information. And so to take claims of personal injuries as a comparison from another area of tort law, it's the PSLA component of a personal injury award which is the analogue to general damages and defamation. And when we come to the cases, we'll see that there are different ways that a personal injury claim can be exaggerated, either by claiming, for example, greater seriousness affecting the bands by which we calculate PSLA, or exaggeration of ongoing needs, and so a larger claim to special damages. And I draw the court's attention to personal injury claims for another reason too, because of course there is now a public policy that general damages in defamation claims shouldn't normally overtop the maximum you get for a really horrific tetraplegic type case in personal injury. And that's about, I think, now about £350,000, maybe slightly higher. Now, of course, no sane person would think that getting a cheque for £350,000 compensates you for being tetraplegic for the rest of your life. But of course, no amount of money can do that. And what we have to do is we're trying to express in money a nature of damage, but it's expressly non-pecuniary. And that's, of course, the same is true of victims of breaches of fundamental rights, torture, false imprisonment, victims of discrimination. It's also true of claimants whose Article 8 privacy rights, including the reputational facet of Article 8, which is infringed by serious defamatory publications, whose suffering needs compensating and whose reputations need vindicating through the media law tools. And so when we talk about these sorts of compensation, we're really talking about compensation, if I can put it this way, in quote marks. It's the best monetary attempt at quantifying the harm that a civil justice system can manage. The second submission under this head is that at common law, the court can't reduce general damages in tort by reason of litigation misconduct. And let me show the court its previous decision in Al-Haq, which is found at tab 5 of the main authorities bundle. I don't know whether the court is using paper or electronics. It's on the electronic bundle, I think, at page 171. And this is a personal injury claim. And if I can go to the headnote first, and the court will see at, and I'll try to give the references on the transcript. I should say, of course, that if the court obviously wants a copy of the transcript, we will, of course, provide it if that's...
That would be helpful, thank you.
So I'll try to get the references on the transcript if that will help the court.
Yes, it will.
So at 616, F to G, there is a holding that other than in insurance claims, the law doesn't deprive a claimant of general damages for personal injury, which would be justified were he honest, even though he'd attempted to perpetrate a fraud upon the court. The same page between G and H is a separate holding, and that's important, a separate holding, that CPR Rule 3.42, sorry, Part 3, Rule 4.2, the power to strike out a claim, did not extend to striking out a claim after the hearing of the trial. Now, that latter holding is clearly overruled by the Supreme Court in Summers and Fairclough. But we submit the first holding still holds good and is good law and is consistent with Summers and Fairclough. Going first to the leading judgment of Lady Justice Smith, who, as the court will know, was a judge who had a lot of experience in personal injury cases. And if I can pick this up at paragraph 16 of the judgment. I'm not going to read this out, but I hope that the court will either be able to, so to speak, read this afterwards or can glance through it as I'm explaining it, unless the court wants me to read things out, but I apprehend it doesn't. At 16 to 17, she highlights the exception for insurance claims. Of course, our law of insurance contracts has the fairly unique concept of ubere mai fide, utmost good faith. And even that principle is restricted to the period prior to the issue of proceedings. That's a point picked up later in this judgment by Lord Justice Toulson at 37. But Lady Justice Smith says the existence of the insurance exception stands as evidence of general rule to the contrary. This is really where the exception does prove the rule. There is no general rule of law that dishonest exaggeration of a genuine claim can result in the dismissal or diminishment of that genuine claim. And at 20 to 21 of the judgment, she says a claimant will not be deprived of damages to which he is entitled because he has fraudulently attempted to obtain more than his entitlement. And the court will see that at 21, she goes on to say, well, there could be a debate about this. There's a legitimate debate about this. And ultimately, she says, insofar as there is a debate about it, the place for that debate to be resolved is not the courts of law, but the court of Parliament. The other judges in the case agreed. You'll see that Lord Justice Moses agreed at 31. Lord Justice Toulson gives a reasoned judgment, and he agrees with Lady Justice Smith at 32. And then between 36, as a matter of substantive law, I didn't understand it to be suggested dishonest behaviour affected their separate causes of action. As Lady Justice Smith has explained, that's novel contrary to well-established practice. I think that's novel in the civil service sense of novel. It's not a term of approbation. And then 37 refers to the special rule of insurance law, and then I'd also invite the court to look at 38, where he summarises the position. He comes back to this point at 46, and I rely, of course, in particular on the second half of 46, from to hold otherwise to the end of that paragraph, and paragraph 50. So that is al-haq. It's important in two respects. It's important because of the point I'm on at the moment, the approach to general damages. It's also going to be important, as I said earlier, when I come back to the precedent point. In the next tab...
There was no reference to Broom and Castle in this case. One wouldn't expect it.
Exactly. There wasn't, but one wouldn't expect it. Exactly. And if I may say, with respect, that's an important point, because when I come to Broom, it's important to remember what Broom was about and what Broom wasn't about, which I think may be behind the point made by my lord. At tab 6, we come to the decision of the Supreme Court, which is about 3 years later, in June 2012. This is a decision of the court given a unanimous decision delivered by Lord Clark. And if we start again with the headnote, the court will see that the first holding directly overrules the second holding in al-haq, i.e. the strikeout point. This court, the Supreme Court, holds that the court does have power under the CPR or its inherent jurisdiction to strike out a claim even after trial if there's been abuse of process. It goes on to say that it would require, quotes, exceptional circumstances, quotes, for that power to be exercised, assuming that there has been a fair trial. In other words, if the abuse has not been such as to prevent a fair trial being held at all, because you run into all sorts of problems with various convention rights, including the proportionality of interference with a claimant's property rights in the judgment which is being denied to him, i.e. in the general damages which are being denied to him. And that is characterised as essentially an A1P1 interference. That's important because in circumstances where loss of a personal injury judgment is a possession engaging A1P1, and remembering also that if the defamatory allegation is sufficiently serious, reputation is a facet of Article 8, which I think my Lord Justice Warby decided at first instance in the Yeoman Times newspapers.
Well, slightly, but anyway, a serious injury to reputation has an impact on private life.
I think that's that. I don't need to go any further than that for today. Yeah. Then the submission for today is how much harder would it be to deny a claimant whose Article 8 rights, as well as his A1P1 rights, would be infringed by the strikeout. Of course, I'm only making that submission as part of the general overview. There wasn't an application for strikeout here, there wasn't a strikeout here. In my respectful submission, there couldn't have been a strikeout here. Coming to the judgment of the court, Lord Clark, as I've said, speaking for the court, begins his discussion of al-haq at 28 and 30. I'm using the paragraph numbers. And he focuses on the power to deprive a claimant of damages for reason of abuse of process. And I respectfully invite the court, in what counsel always somewhat ridiculously called the court's spare time, which never exists, to glance through, to read through 36 to 45. But especially, perhaps now, we can focus on 40, where he there refers to this court's decision in Masood and Zahur, which left the power to strike out for abuse of process even after trial intact. And he says that the exercise should be incredibly rare. And in considering proportionality as a restriction on the exercise of the power, at paragraph 50, and again at 53, Lord Clerk, in approving both Ulhak and Masur on this point, and again indeed at 61, identifies the levers, if I can call it that were generally available to the court instead of depriving or diminishing a dishonest claimant's general damages. So, for example, you can award costs on the indemnity basis, insofar as court time was wasted by the dishonest aspect of the claim, but I would say not otherwise than caused by the dishonesty. Now, I do contrast that with this case where my client was ordered to pay 100% of the costs on the indemnity basis, but again, we're not appealing from that. He makes that point at 53 and 61. Contempt proceedings, 51 and 61, they can of course lead to committal to prison in cases. Criminal proceedings for offences against Administration of Justice Act, loss of interest on damages, and of course any uplift to damages that might otherwise have resulted from the dishonesty. And of course, generally, this is a point made at 52, a dishonest claimant is less likely to be believed on other points as well. I mean, we all know.
Can I just ask one question?
Yeah.
One of the consequences, to put it neutrally, that there's identified in these passages is the loss of interest, which is a compensatory measure. And might it be said that if it's right to accept the principle as they did, that you could strike out the whole claim after trial on abuse grounds, the lesser measure of reducing damages is also a legitimate course of action to take. It's less, and obviously one would expect it to be in exceptional cases only. Would that make sense?
Well, of course it makes sense. My response to it would be this. One has to distinguish between two conceptual situations. You can say that this claimant has behaved so badly that he's not entitled to anything from the court at all. It's just an abuse. And you can say that before trial, and you can say that after trial. What you can't do, consistently with principle in my submission, is to say, we've been able to have a fair trial. The claimant's entitled, as a matter of compensation, to £50,000. But because he's not a very nice guy, or he's lied, or whatever the litigation misconduct is, I'm only going to give him 23,000. Now, of course, I accept my Lord's point that 23 is more than zero.
Yeah.
Of course,
I can see that, and that's why I was a bit puzzled by the reduction in interest.
The reduction in interest is, can I put it this way? The reduction in interest may need looking at in another case. Because the way I would put my Lord's point, if I can respectfully, I'll stop saying respectfully, just take this.
Yes.
The way I put my Lord's point is this. It could be argued that denying somebody interest also offends against the restitutio principle. So it may be the case that if I'm right, I'm also right, at least in some cases, on interest as well.
And we're not concerned with it.
We're not concerned with that, and that's why I haven't gone into it. But if I may say, I think that is the answer to my Lord's point.
Lord Wolfson, can I ask you about a slightly different aspect of this issue, which I would welcome your assistance on? I can understand that if a fair trial is not possible, then the abuse jurisdiction might be exercisable beforehand or perhaps during the course of a trial. What speaking for myself, I'm having difficulty understanding is how, if you can help me with what would be a legitimate instance on your submission where the court could strike out because of litigation misconduct after trial, because that is tantamount to saying you get nothing.
Yeah.
Now, if you can do that, picking up my Lord's point, why can't you do something which arguably is lesser, which is to reduce your damages?
If I may say, that is, it's obviously a very good point. And let me try and answer it three ways. These are going to be independent answers, so you might like some more than others. The first part of the answer is, although the Supreme Court says in Summers that you can strike out at the end of a trial, I don't know whether my Lord's had the opportunity to look at this judgment in full, but when my Lord does, you'll see that the restrictions put on it are so extreme that one wonders what the case would be. And of course, they're leaving it open as an intellectual possibility.
Yes, they say never, never say never.
They say never say never. I mean, it's, you know, James Bond doesn't often appear as never say die, but, you know, it's pretty close to saying, well, we're not going to say never. But if you try and ask us, as my Lord is asking me, of an example, we might actually struggle. Now, that's not an attempt to avoid my Lord's question. It's really saying that what Summers is doing is saying, as my Lord Justice Warby says, we're not going to rule it out as a matter of principle. Maybe there are cases, I don't know, maybe if at the end of the trial you find that all of the documents in the trial you find right at the end have all been fraudulent. Every witness has been suborned. You don't know what's been destroyed, what's been lost. You don't even know whether the person who went into the witness box and said they're Francis Smith was actually Francis Smith or Joe Black. I'm just trying to... There are cases where, frankly, the judge may be left with thinking, well, just a minute, this whole thing was a charade. I didn't know when I started. I didn't even know on day 75, but I know now. And frankly, I'm not even going to give a judgment. I'm just throwing this out. Because if I'd known this on day one, I would have thrown it out. So maybe that's one answer to my Lord's question. Another answer to my Lord's question is this, and it goes back to the conceptual point, which is there is still a conceptual difference between denying somebody the right either to come to court or get a judgment from the court, and saying the court has found you're entitled, let me use my same numbers, to £50,000, but I'm only going to give you 23,000. Now, of course, if I can put it this way, my Lord's question sort of piggybacks off or is related to my Lord Justice Warby's question, because it comes to the same point. If you can do the greater, why can't you do the lesser?
Yes.
And so the two answers really, perhaps there are really two answers rather than three, is first of all, the greater really will hardly ever be done. And true greater is greater than the lesser, but they're conceptually different. And you can't, maybe I put it this way, you can't say that because in the 1 in a billion case, I can kick the whole thing out. That means in, and frankly, quite a lot of cases where people gild the lily, frankly, I'm going to give you nothing. I'm just going to interfere with general damage. I hope that's at least the beginnings of an answer to my Lord's
Yes,
question.
that's helpful.
Now, we say that the upshot of the Supreme Court's decision in Summers is to overrule, as I've said, the Court of Appeal in Al-Haq on the second holding, but not only did it not overrule on the first holding, it positively endorses the general principle that where strikeout for abuse of process is not the appropriate response to litigation misconduct by a claimant, the avenues for the court's disapprobation are costs, interest, square brackets, contempt or criminal offences, but not diminishment of the general compensatory damages. My learned junior, Mr. Callas, suggests there's another answer. Let me just interpose to my Lord Justice Warby's question, maybe this. Interest under Section 35A of the Senior Courts Act is a discretionary power. General damages is a sort of hard-edged legal issue. In other words, the claimant is entitled to £50,000 or £40,000 or whatever, but that's not a matter of discretion. And so the answer might lie there as well. I'm grateful to my learned junior.
Thank you.
Now, the decision in Summers was, of course, something of a disappointment to the insurance industry. And that was reflected when Parliament passed Section 57 of the Criminal Justice and Courts Act 2015. That's at tab 11. I don't think we need to go to it. Let me just tell the court what it says. It mandates the court, if the court finds the claimant has been, quotes, fundamentally dishonest, quotes, in relation to the primary claim or a related claim, it mandates the court to dismiss the claim unless the claimant would suffer, quotes, substantial injustice if the claim was dismissed, close quotes. Now, that only applies to personal injury cases, underlined twice in red. Third point under this head, the proper diminishment of damages at common law under the restitutio principle. Of course, where a claimant has committed litigation misconduct, and in cases where a claimant has not committed litigation misconduct, damages can always be reduced consistently with the restitutio principle. But the critical point is the reduction of damages is not related to the litigation misconduct. Litigation misconduct can never be a reason, in my respectful submission, to reduce general damages, except, obviously, to exclude the effect of the exaggeration on the general damages. So if you were to say in a personal injury case, the damage to my knee is in the very severe category, and it's in the moderate category, you only get damages for a moderate, PSLA damages for a moderate knee.
That's really not reducing, that's ascertaining.
Exactly. And that's why, if I may say, the nomenclature here is often so difficult. Sometimes reduce is used.
Yes.
Exactly.
Well, it's often a difficult process in these areas where, as you say, the numbers, the money is incommensurate with the injury. Because you don't have an easy benchmark to start with. You can't say this libel is worth this much, and then move up and down as you would in a sentencing exercise.
Yes. But equally, to take my person who came along and said, I've got an extremely severe knee injury, and it turns out to be moderately severe. Ignoring, putting to one side the statute, at common law, the claimant wouldn't get nothing, or £1 in nominal damages. The claimant will get what they're entitled to, a broken knee on the moderately severe scale. They might get the book thrown at them in costs and all the rest of it, but that's a different matter. Now, beyond the exaggerated element being taken out of account, the same restitutio principle would also allow diminishment or enlargement of general damages where the loss suffered is truly greater or smaller because of personal factors of the claimant. So, for example, the same broken leg or knee injury, a person with a bright career in football ahead of them is likely to suffer greater mental anguish at the loss of that career than a person who never played sport at all. I'm not straying into special damages there, that's different. I'm still in general damages, mental anguish. And by the same yardstick, in my submission, the same allegation may have a variable effect on a person's reputation depending on against whom the allegation is made. So, for example, if serious personal dishonesty is alleged against a legal professional or a senior doctor, that's going to be a greater source of anguish because it could lead to professional striking off. And I can give other examples. The restitutio principle may also be relevant, and again, this is very common in personal injury cases, where there's contributory negligence. And that looks at the claimant's own fault in causing the injury for which they're claiming. And if they bear some responsibility for the circumstances leading up to the injury, that's almost always a factor in the calculation of PSLA. And so, in the defamation context, if the claimant has baited the defendant or the defamatory allegations arise in the course of disreputable behaviour by both parties, the role and conduct of the claimant may be relevant to general damages in defamation in a similar way to contributory negligence applies to PSLA. If what you're claiming about is in some way caused by your own conduct prior to the injury being suffered or contemporaneously with it, then you're likely not to get the full general damages you might otherwise have got if you behaved properly. Importantly, in that limited sense, claimant's conduct may be relevant to the assessment of general damages and defamation. But it's important to ascertain, as I hope I'm doing, the different juridical basis for that claimant's conduct and rationale for that avenue of mitigation. It's not claimant's conduct in and around the trial, it's claimant's conduct in and around the allegation on which the claimant is claiming. And it's important not to, when we're talking about claimant's conduct, not to elide that sort of claimant's conduct with litigation misconduct, which will always, of necessity, happen many years later. Well, happen sometime later. Hopefully, it'll happen quicker than it does sometimes at the moment. The last point under this head, the proper consequences of litigation misconduct by the claimant. And I've touched on this already, but let me make this absolutely clear. It is no part of my case that serious litigation misconduct should pass with impunity. While the claimant at common law should get, in my submission, his full general damages for PSLA, in my example for the moderately severe knee injury, as we've seen, the court has got plenty of other tools to punish him for dishonesty. We've seen from Summers that the court can strike out before square brackets, even after close square brackets trial. It is truly exceptional, I accept, but it's there. But the essential submission is the court can't, if I can put it this way, the court can't mix and match. If the court decides this is not an exceptional case where it will strike out the claim, and so goes on to award the claimant general damages for PSLA, in my example for the moderately severe knee injury, the court has to award those damages in full. Pausing there, when I say in full, that will include at that stage contributory negligence, because that's still in full. But what it can't do is then to impose some sort of dishonesty tax or litigation misconduct reduction, or whatever we want to call it. And that is, we submit, the error made by Mr. Justice Tugendhat in Joseph and Spiller. We'll come to that. Of course, if not struck out for abuse of process, there are a number of other tools in the toolbox. I think I've gone through some of them. Perhaps I didn't mention the court can, of course, also deny non-pecuniary remedies, such as injunctive relief, declaratory relief, on the basis of unclean hands. I don't think I mentioned that one earlier. And those measures and that principle in my submission apply to tort claims generally. They apply every bit as much to defamation cases as they do to personal injury cases. And again, I put section 57 on the side. That's the exception that proves the rule. It either proves the rule, if I want to put it that way, or it's certainly irrelevant. I don't really need to say very much more about that. So, as I've said, a claimant obviously can't get general damages or special damages insofar as those damages depend on the dishonesty. So in this case, let's assume that my client had not dropped the plea about overseas conferences before the trial. He wouldn't have been able to get general damages on the basis of the overseas conferences plea. And that will go for special damages as well. Let's say my client had said, I was disinvited to all these overseas conferences, and there would have been paid £10,000 a pop for each conference. So I'm claiming, I think it was 11. I'm claiming 11 lots of £10,000. Of course, on the judge's finding, he wouldn't get that in special damages either. But none of that is the case, and indeed, this is not a strikeout case either. The judge didn't order it, the defendant didn't seek it, there's no respondent's notice asserting it either. Now, I've dealt just now with general damages and special damages. So far as aggravated damages are concerned, again, it's not directly relevant to this appeal, but let me just say a word on it so the court sees, at least conceptually, I hope that my submissions cohere. So far as aggravated damages are concerned, if a court disbelieves claims of distress, it could certainly refuse to award aggravated damages entirely. And I would accept that the court may also be entitled to refuse to award aggravated damages on the basis of the claimant's own litigation misconduct. The reason for that, it seems to me, I mean, it's not necessary for this appeal, but it seems to me the answer would be this. Just as aggravated damages are often given because of the way the defendant ran the trial, perhaps therefore also they should be able to be withheld for the way the claimant has run the trial. I don't, I think, need to go any further than that. In this case, as I said, the aggravated damages plea was dropped off with the PTR.
Lord Wolfson,
yes.
sorry, I'm sorry to interrupt you. If you're going on to a related point, I don't want to interrupt you.
I was just going to make one other point, and then perhaps can I take my Lord's question then? I'm grateful. So just to finish this point, a court can also punish a defamation claimant by refusing non-pecuniary relief. And I was just going to make the point that in this case, the learned judge really, he didn't really throw the book at my client, he threw the library at my client. We didn't get an injunction, we didn't get an undertaking, we had to pay the cost and on the indemnity basis, and we got a pound. But my Lord's question.
Just coming really to the core submission that lies at the heart of your appeal. What if the facts are that the general damages being claimed are to vindicate the claimant's reputation, and the relevant part of the reputation, he says, is that I am an honest man? And then the judge finds, I'm not talking about this case, I'm doing what you're doing, which is asking the conceptual question. Is a claimant who says I'm an honest man, but who demonstrates through his dishonest conduct at the trial that he's not, is he entitled to anything?
If I may say, my Lord has absolutely hit on what's now going to be the next topic I'm coming to, because this is absolutely the critical point. Because, so to speak, if I'm wrong on the first point, I've lost there. If I'm right on the first point, this point is obviously relevant. Right. In other words, even if you're right, what are we compensating you for? If I can reformulate my Lord's question.
Yes.
So I'm actually going to come to this.
Right.
And this is, so I'm sorry for the Radio 2 segue, but this is the second part of my submissions, which I'm going to be focusing on. So what I'm going to be looking at is this, and I hope in the course of this second part, I'm going to answer my Lord's question. Of course, if I haven't, I'm sure my Lord will point that out to me, but I'm going to seek to.
Of course.
In the second part of these submissions, I'm going to look at two things. First, the categories of evidence which the law of defamation has traditionally said can be admitted to mitigate general damages. And secondly, whether those categories of evidence in mitigation of general damages are consistent with what I've set out to be the general law of tort in the first part of my submissions. And if not, which decisions have gone outside the lines. And the leitmotif of the second part of these submissions is that in the law of defamation, the juridical basis of a court reducing a well-founded claim for general damages is perhaps a little more obscure, and sometimes different principles have been elided. And I therefore submit that we have to distinguish, again, conceptually, and the court will have appreciated, I haven't even looked at Mr. Justice Chamberlain's judgment yet, but in my submission it's important to get the concepts in place before I do so. We've got to distinguish between two sorts of case. They are conceptually distinct in my submission. First, cases where the application of the restitutio principle itself demands a reduction in general damages, i.e. where compensatable loss on closer or proper analysis is less than it may first appear by reason of mitigation properly so called. And my Lord Justice Singh will see that that is at least, as I say, the beginnings of an answer to my Lord's point. Secondly, cases where general damages to which a claimant has properly founded in a good claim are reduced without regard to the restitutio principle, purely on the basis of punishment for his litigation misconduct. And we submit, of course, that that second type of case, which is very rare, is unprincipled, wrong, and contrary to the authorities. Now, the common law of the tort of defamation has developed recognised categories of evidence admissible as to mitigation through the accretion of cases. A good way to summarise them, and I'm just going to give the court, because I'm not seeking to rewrite the law of defamation, I'm just going to give the court the reference to this in two of the textbooks. We have them both in the authorities. The first is Gatley at 34080, that's 356 of the electronic bundle. And secondly, Duncan and Neil, at 2519, that's at 375 of the electronic bundle. Gatley, this bit of Gatley is the bit at tab 12, Duncan and Neil is at 13.
Thank
Now, let me just, they both give the same 7. They give them unhelpfully in different orders. So let me just read Gatley, if I may, into the record, so to speak. 1, claimant's bad reputation. 2, facts relevant to the contextual background to which the defamatory publication came to be made. Burstein particulars, they've come to be called. 3, evidence properly before the court on some other issue. 4, facts which tend to disprove malice. 5, claimant's own conduct. 6, apologies or other amends. 7, damages already recovered for the same libel. Now, interestingly, when the court comes to look at Duncan and Neal, the court will see that 2519, where these 7 are set out in a different form, a different order, says at the end this: the defendant should give notice of the matters relied upon in mitigation of damages. Footnote 1. Footnote 1 says this: the CPR imposes specific requirements on the claimant to set out their case on damages, and then the defendant is subject to a general requirement to set out the case in response. The reason why I mention that now is because I'll be coming back to the question of what evidence is. And importantly, if a claimant says, I was in Manchester on Tuesday, and the judge doesn't believe him, is that evidence that he wasn't? I'll be coming back to that point. Now, of the 7 I've read out, 3 we can put to one side for today immediately. We can put to one side apology or offer of amends, including the statutory offer under sections 2 to 4 of the Defamation Act 96. We can put to one side fact negativing malice. We can put to one side damages already received. Now, all of those categories can be obviously consistent with the restitutio principle. I don't really need to explain why. That's obvious. None of the categories are relevant to this case either. So let me focus on the 4 that remain. Now, a helpful summary of these 4 is set out in my learned friend's written argument. And can I invite the court? It's a convenient place to take it from, and I'm grateful to learned friend and the team for putting it out in this way. So if we take up her skeleton at paragraph 34, please. And I appreciate the court will have seen this. I'm not going to read it out. But just to identify, 34.1 is general bad reputation. 34.4 is Burstein particulars, the background context. 34.2 is evidence properly before the court on another issue, Chamberlain. And 34.3 is claimant's conduct. Now, let me take, I'm going to look at those in turn, if I may, and then I'm going to look at the defamation cases which stray beyond the proper bounds of those categories of evidence, and then I'm going to look at the facts of the present case through this prism. So let me start with general bad reputation. The law of general bad reputation is relatively well settled. It has to be in the same sector of the claimant's reputation as the libel, but it has to be his general reputation. It's impermissible to rely on specific disreputable acts, with certain exceptions, in particular criminal convictions or judicial strictures in previous, underlined previous, civil litigation. See Turner and NGN at 48. But such evidence is confined to a general bad reputation prior to or at the time of the publication. See Gatling at 34-084, and in particular footnote 389, which cites the House of Lords in Dingle, and Duncan and Neal make the same point on the timing issue at 25.21. So in Turner, this category of evidence could only apply to previous judicial criticisms in previous litigation. It couldn't encompass judicial strictures, criticisms, or findings in the trial of the action itself. General bad reputation, therefore, as a category of evidence going to reduce general damages, is in my submission consistent with the restitutio principle. It is, however, irrelevant to litigation misconduct post-dating publication, and therefore it's irrelevant to the present case in particular. Just pausing there. So, I've still got my Lord of Justice Singh's question reverberating in my mind. I'm conscious that I may be answering it, so to speak, in tranches, but part of what I've just said, I hope, is part of the answer. Second, directly relevant background facts, or Burstein particulars. This is Roman 4 of my learned friend's paragraph 34. Evidence called on Burstein particulars can also be a legitimate category of evidence for mitigating general damages. And again, in our submission, it's consistent with the restitutio principle. To give my lords and my lady the reference, Gatley discusses Burstein mitigation at 34092, 34095, Duncan and Neal at 25.26. Now, although I accept that there is not a strict rule that, quotes, directly relevant factual background, close quotes, is temporally limited to matters prior to publication, the exact proximity test, which incorporates both relevance to the allegation at issue, which is necessarily not true, and closeness in time, means that matters happening years later will almost never be, quote, directly relevant, factual background, close quotes. That point is made at Gatley, in particular, at 34095. The relevance of Burstein for this appeal is that it shows that there is a way of allowing relevant particulars to be admitted, even where there is not enough in all of them taken together to provide for a pleadable defence of truth or honest opinion or public interest, but nonetheless, they are manifestly relevant. Now, the findings of the learned judge in this case, as to dishonesty, were not findings on pleaded Burstein particulars at all, nor could they have been. And there's no respondent notice, as I say, on this point either. And it follows, therefore, in my submission, that Burstein particulars, i.e. the category of evidence concerning directly relevant factual backgrounds, are again irrelevant to this appeal. And the court will appreciate that, I say, I'm not trying to rewrite the law of defamation. The court may think, well, why are you going to this material then? Because I want to show how all of these factors fit into the restitutio principle and then contrast claimant's conduct. Or at least, well, I won't give the game away too much, at least half claimant's conduct. Third, evidence properly before the court. And this is my learned friend's skeleton at 34.2. Yes. Now, one has to remember in this context that, as perhaps with a number of facets of the law of defamation, the principles of law here have been distilled from cases going back quite a lot of time. And for much of that time, prior to Section 11 of the Defamation Act 2013, nearly all defamation actions were heard by juries. And any party had a, can I put it this way, a quasi-constitutional right to trial by jury in a defamation action. More importantly, for present purposes, it was the jury as a tribunal of fact who assessed general damages. Now, as the jury would have heard the ultimately unsuccessful defences of justification, as truth used to be called, fair comment, or Reynolds privilege, now truth, honest opinion, or public interest, that we know what we're talking about. As a jury would have heard all that stuff, all that evidence, they were entitled to have regard to the evidence adduced on those positive defences in order to mitigate damage. And so, when we see references to partial truth in the authorities, whether that arises in the context of a defence of justification or a defence of fair comment, what it means is that that was insufficient to defeat liability on the basis that the statement was substantially true. But it could mitigate general damages because the statement was partially true. Partial truth arising from evidence properly before the court reflected the restitutio principle perfectly, in my submission. The classic cases are Chamberlain and Grobbelaar and Turner at 42 to 46, but Fly Me Now, a decision of my Lord Justice Warby at 127, is an equally good example of a case where defences of justification and qualified privilege were run to trial. So Duncan and Neal explains this facet of mitigation at 25.27, suggesting there that the archetypal instances are where underlying facts are proved by evidence, and I do underline evidence, called at the trial of a substantive defence, i.e. the classic partial truth situation, such as truth or honest opinion. Now, the case that has perhaps developed the law a modest step further, but again is consistent in my submission with principle, is the decision of Mr. Justice Nicklin, Indeer and Sadler. Can I just take the court to this quickly? It's in the supplemental authorities bundle. And the court will see also now why I'm certainly not objecting to this going in. It's quite useful to look at, and I'm grateful. It's at tab 8. I'm going to have to ask the court to read a chunk of it outside court, but can I just explain why I'm going to it? In Deer, the allegation was that In Deer, the allegation was that in their true, natural and ordinary meaning, the claimant had threatened to slit the throat of the defendant. That's at paragraph 22. There were a number of issues at trial, including a defence of truth under section 2 of the 2013 Act. That's at paragraph 24. And that defence of truth was pegged prior to the determination of meaning to a Lucas box meaning of, and you'll see this at 20, when crossed in family matters, the claimant is prone to anger, intimidating and bullying behaviour and making wild threats. The critical passage in the learned judge's judgment is from 108 to 122, and that's why I haven't got time to go through all of that now. But I will invite the court now to look at 117 to 119. And let's say if the court could afterwards look at 108 to 122. But if we pick it up at 170 for the moment, you'll see that what the judge is doing is referring back to the position before the jury, when he says it's highly doubtful the jury could have expected to put all this stuff out of their mind, and refers to a classic statement by Lord Denning in Speedle. And then at 118, he says the rule is not limited to evidence adduced on justification, now truth, or fair comment, now honest opinion, insofar as it supported another positive defence, i.e. public interest or qualified privilege. That is almost certainly correct. In other words, it shouldn't necessarily be limited just to those two positive defences. It can go to others. Although, given that mitigation must satisfy the restitutio principle, it might be a rare case that evidence would properly be before a court to substantiate the partial truth of a sting similar to the libel, other than on a positive defence.
Sorry, Lord Wilson, I was not paying proper attention. Where were you reading from just then?
Oh, sorry, I was paraphrasing what he's saying at 118. So at 118,
I see.
Yes, sorry, my lord is right. I think I elided what the learned judge was saying and what I was saying.
I was reading 118, that was why I was puzzled, but there we are.
In which case, my apologies.
No, fine.
But the point we're making is that we're not saying that learned judge here is wrong in principle. The dear extension, if I can put it that way, of this category of evidence is to other positive defences is not intrinsically contrary to the restitutio principle. But in this case, there was no positive defence run at all. Truth, public interest, abuse of process had all been dropped in October 2021, more than 6 months before the trial. Deere at 119, and to a lesser extent back in 117, but in particular at 119, raises a separate issue of some importance, which is particularly relevant to this category. Now, as my friend's skeleton points out, when one goes back to her paragraph 34, she says various categories of evidence have been identified over the years. I agree. Underline the word evidence. 34, 1, 2, 3, and 4 all begin with the word evidence. And with respect, she's right to do so. This is a discussion of the categories of evidence admissible in mitigation. Now, there's no difficulty with evidence of the claimant's dishonesty in matters relating to the libel being properly before the court. And a good example is in the Fly Me Now case, where there was evidence before the court of the dishonesty in the claimant's communications to the defendant at the time. By contrast, one of the unusual anomalies of the present case is that the misconduct or the facts relied on to reduce general damages were not evidence properly before the court at all. And I say that for two reasons. First of all, the finding of dishonesty by the learned judge is not evidence of anything at all. It's the judge's own assessment of the evidence in his capacity as a tribunal of fact. And the analogue I would give is this. In the jury trial era, the jury couldn't reduce damages because of evidence they'd heard, whether of the partial truth of the defamatory allegation or otherwise. So I think I may have introduced a knot in the wrong place there. Let me start again. The analogue for this in the jury trial era would not be the jury reducing damages because of evidence they'd heard, whether of the partial truth of the defamatory allegation or otherwise. But the analogue in the jury trial era would be the jury reducing damages based on their own assessment in their capacity as tribunal of fact of the credibility of the claimant as a witness. And there's no support in my submission in the authorities for that as a category of evidence admissible for reducing damages in any event. The jury's own assessment of credibility is not evidence at all. And the position is no different now that we have a judge sitting and not a jury. And I can put the same point, I'm still on my first point, in a slightly different way. It's far from unusual, if I can put it this way, for the evidence relevant to damage to reputation, both as to serious harm and on damages, to come from the claimant as the sole or principal witness. That's far from unusual. The claimant, only really the claimant can speak to his own distress. He's usually also best placed to testify as to the effect on his reputation. If that evidence is rejected, it's as likely to be rejected because he's been disbelieved after cross-examination as because there is some conflicting evidence on the same subject from some other source. A claimant's evidence on these points is routinely not accepted in full, with the implication that the court is not believing him, at least in part, on what he's saying. And if it's right, therefore, that that itself becomes evidence of dishonesty or misconduct, one would expect to see more than a trace of that in the authorities on the approach to general damages, which we have now, or in the directions judges gave to juries pre-2014.
Lord Wolfson, suppose it's only during the course of the trial that it becomes apparent that the claimant is a liar. Again, I'm not commenting on this case, I'm just testing the point of principle. Suppose the claimant goes so far as to accept in cross-examination that he's a liar, that he's perjured himself in the witness box. Does it follow from your submission that in the old days the jury and these days the judge cannot take that into account because, are you saying that's not evidence?
I'm going to start worrying that my lord has seen my notes, because that is absolutely the next point.
I can assure you I have not.
that is the second point to which I was coming.
All right.
And let me answer my lord's point before coming to it. In my lord's example, the claimant admitted it in the witness box.
Right.
That's evidence.
So that's why it's evidence.
That's why it's evidence.
I see. All right.
Yeah.
But I think your submission was a moment ago that the tribunal of fact may come to a finding of fact, but simply because it does come to a finding of fact, that does not constitute evidence.
For these purposes, yes.
Forgive me for interrupting you, Lord Wolfson. May I just test? I've been thinking about the last proposition that you put, and I just want to test where that gets us in terms of whether it actually makes any sense. I don't mean that disrespectfully.
Yeah.
As I understand it, the point you're making is that an impression that is formed of the credibility, honesty, etc. of the claimant as a witness is not evidence at all. Get that entirely. And you made the point that in certain cases, obviously, that may be the only basis on which certain aspects of his case are rejected by the judge or the jury, as the case may be. Let me just test it this way. Is not the logical concomitant of that submission that if it so happened in a particular case that the defendant called a witness who impressed the jury, and that witness gave evidence which the jury believed, which comprehensively demolished the reputation of the claimant and showed that he was lying, then that evidence could be taken into account. But if the demolition of his reputation is purely he's the author of his own misfortune, it can't.
It turns on what evidence is relevant and admissible on each issue. In my lady's example, if the evidence and the witness was properly admissible on the first of the categories which I've given, then it would go to mitigation of damage. But it would have to satisfy the characteristics of that. Now, I'm going to come to a separate point on that in this case, but I appreciate at the moment we're talking conception. The second part of the answer to my lady's question may well be actually, I think, the same point I was just about to make. It's the well. Can I take the court to this point and see whether I've answered the question? And if I haven't, obviously the court will come back. But I said I had two points. Let me put the second one, which is linked to the first one, but it stands on its own 2 feet as well. And I'm only trying to explain the proposition, and frankly, it doesn't really matter which explanation the court likes better. The correct position on evidence adduced to credit is set out in Gatley at 34090 to 34091. And can I just invite the court to take that up? It's in the main authorities bundle at tab 12. And the court should see a heading, cross-examination after credit permitted.
So
and
could you give me the reference again?
Oh, sorry, it's tab 12.
Tab 12 page.
It's tab 30. It's paragraph 34090. It's
Thank you.
I think it's 60.
Yeah. Thank you.
And perhaps the court could just, so to speak, read this with me. In the absence of clear truth, the defendant can't give evidence of any incident in the claimant's past life which tend to establish the truth of the libel. He can, if the claimant goes into the witness box, cross-examine him as a credit, although it may incidentally elicit such incidents. May also elicit other discreditable incidents in the claimant's life. And then a citation. Cross-examination is within discretion. Justification is it may elicit facts tending to show the claimant's evidence not worthy of belief, except insofar as it can be so justified, it may be properly disallowed. If the claimant does no more in a case where truth is not pleaded, then give evidence as to his background, the falsity of the libel and the effect upon him, it can only be cross-examined to the credit, with the view to showing his evidence untrue on those matters which are an issue, which don't include the falsity of the libel. Claimant's denial. If incidents about which the claimant has been cross-examined are denied by him, no further evidence can usually be called to rebut the denials. The court isn't bound to accept the claimant's denials, but those denials, though unaccepted, afford no evidence that the incidents have taken place, and the answers given to such cross-examination are not relevant on the issue of mitigation of damages, only have the potential to damage the claimant's credibility in respect of other evidence. And footnote 411, which I skipped over at the end of 34090, cites the decision of this court in Williams and MGN in 1990. Now, in 34091, the court will see footnotes 413 and 414, and if we sort of scroll down or turn over, as the case may be, the court will see what those footnotes say. At 412, there are three recognised exceptions where the witness has been convicted of a crime, inconsistent statements, witnesses biased in favour of the party calling him. And then 413 cites the famous illustration of Lord Justice Scruton in Hobson Tinling. If by cross-examination to credit you prove a man's oath cannot be relied upon, and he's sworn he didn't go to Rome on May the 1st, you don't therefore prove he did go to Rome on May the 1st, there's simply no evidence on the subject.
I understand that point.
Denials in cross-examination as to credit don't constitute evidence.
And I understand that point, but do they constitute evidence that he's a liar?
The judge is entitled to conclude that he's a liar on that point. The question then becomes, where does that go? And at that point I'll be coming back to. Absolutely. What you can't do, in my respectful submission, is to say, well, because he's a liar over here, he's a liar generally and it all falls away. But I'm certainly not going so far as to say the judge can't say he's a liar. Of course. I started off the appeal by saying I'm not interfering with the findings of fact.
Yes.
Now, the situation is different if the claimant admits dishonesty, to pick up my Lord Justice Singh's point from earlier. Then there is clearly evidence before the court. And it really is evidence. That's not the assessment of the tribunal. And it should be noted that in Joseph and Spiller, the dishonesty of the claimant was to some extent admitted. To some extent. See at paragraphs 154 and 175. And counsel, in that case, conceded that no submissions to the contrary could be made. I mean, a real sort of hands up from counsel's row. Now, that point, when the court goes back to Deere, which I showed the court earlier, the court will see that this is what Mr. Justice Nicklin was also getting at in that paragraph 117, where he cites Lord Denning in Speedle. And when the court, having, I hope, heard these submissions, goes back to Deere at 117 and 119, in particular, the court will see that, let me just read it out now. In this case, the evidence on the Fiat and car incidents was admitted on the issue of credibility and his propensity to act or threaten to act in a violent manner. The usual rule on issues of credit is that if the claimant denies what's put to him in cross-examination, no further evidence can be called to rebut the denial. But if he admits the conduct alleged, then that becomes evidence in the case. Then jumping to the end of the paragraph, the other credibility evidence that was adduced at trial was either disputed or it is irrelevant, and I ignore that when considering the factors that reduce the award of damages. And he includes the word disputed in what he's ignoring. Contrast what was admitted. Now, this point, although Gatling, as I said earlier, in the passage which I was showing the court at 34090 and 34091, when Gatley comes back to this at 34096, and here I should say that I say this with genuine respect, given who the editors of Gatley are, I do submit that when the court looks at Gatley 34096, I'm on, I think it's 369 of the bundle, there are a number of sentences in that paragraph. The first 3 sentences are with respect correct. The 5th sentence is correct in summarising Joseph and Spiller, although of course we say Joseph and Spiller isn't right, but insofar as it's saying what it says, I can't take issue with it. But the 4th sentence is really respectfully potentially misleading because it uses the word may without any limits. May extend, that must be extend rather than extend, may extend to evidence introduced on credibility. I think that must be or to show propensity to act in a particular manner. Mr. Justice Nicklin, to which this sentence refers, was very careful, as the court will see in 119 in Deere, to acknowledge that evidence adduced on credit alone was potentially admissible evidence on mitigation if it was admitted by the claimant. And so the citation at 439, footnote 439, to Deere at 118 and Bokova at 29 is correct about the evidence properly before the court category not being strictly limited to evidence being adduced on truth or honest opinion defences. It can go to other positive defences also, agreed, but omits the more important reference to Deere at 119 explaining the limits of evidence adduced solely on the issue of credit. So to that extent, I do have an issue with that sentence of Gatley as it's expressed. Now, returning then, on this point, to my learned friend Skeleton at 34 Roman 2, we can see that this case doesn't fall within this category of evidence at all. And the issue simply is this, that the judge's assessment of my client's oral evidence denied by my client, wasn't itself evidence, nor is it properly before the court. That's a submission which I've been making. Again, there's no respondent's notice on this point either.
There was some evidence before the court as part of the process of concluding that the claimant had lied about these matters. It was the evidence of what he had said about the invitations and the withdrawal of them. So there's evidence about that, although he wasn't relying on it.
Exactly.
And then the judge makes a finding, and you'll come to all of this later.
My lord, yes.
So to that limited extent, there's nothing discreditable about what he said until you add to it some further element. Yeah,
absolutely, yes. That evidence doesn't get you home on this point.
No.
Yeah. So let me now turn to the last of the 4 categories, which is the conduct of the claimant. Because, so to speak, this is where it's at for the purposes of this appeal. We don't dispute in principle that the conduct of a claimant is capable of being a legitimate category of evidence for mitigating general damages. And I said earlier that I made the analogy with contributory negligence in the personal injury context. And looking at my learned friend Skeleton, and this is Roman 3, my learned friend is quite right to cite primarily the provocation of the libel complained of. That's the example in Broome, it's reiterated by the court in Burstein, and indeed Fly Me Now and Riley. All correct. Where we respectfully say paragraph 3 goes wrong is the second bit, that it's the or. I mean, that or, if that or was changed to but not, then we'd be happy. But not all. And the crux of this appeal, therefore, is that Chamberlain J is wrongly decided, and to the extent that the first instance decisions in Joseph and Fly Me Now have adopted the error, that they are also wrong. And so the narrow compass of this appeal really lies in that sort of half bit of the paragraph of 34.3. Does claimant's conduct, does that category of evidence admissible in mitigation of damages extend to litigation misconduct or not? Now, against that background, now let me turn to the defamation cases. And again, I'm really going to seek to focus on the point at issue and not rewrite the law of defamation. Let me start with Broom, which is at tab 2 of the authorities. I'm conscious this is going to be a decision which each member of the court will have seen on numerous occasions, perhaps in different contexts. Let me just take a moment just to remind the court what it's about. The claimant sued two people, and that's important to remember. The claimant sued the author of the book and the publisher. And the jury awarded £40,000, of which £15,000 were said to be compensatory and £25,000 were said to be exemplary against the defendants jointly. Both defendants appealed the exemplary damages to the Court of Appeal, but only the author appealed the compensatory damages. The Court of Appeal upheld the exemplary damages, and the publishers, but not the author, appealed to the House of Lords on the issue of exemplary damages only. See Lord Hailsham at page 1051 D2F. This is a defendant's appeal. It's well settled that a defendant can aggravate injury to reputation by what he does after publication, including the way in which he runs a case at trial. As I said earlier, a hopeless truth defence pursued to the bitter end can give rise to aggravated damages. And so because this is a defendant's appeal, whatever is said about claimant's conduct is necessarily obiter, in my submission. In parentheses, but as we're here, at page 1052E to 1055C, Lord Hailsham also deals with the precedent point. The Court of Appeal had sort of indicated to judges that they maybe needn't follow the House of Lords on particular points which Lord Hailsham was not particularly enamoured with. But sticking on the damages point, at 1060 B to D, the Court could turn through to that. That is the core statement of principle to the ratio on exemplary damages. They're discretionary, they're to be awarded against the defendant to punish conduct where compensatory damages would be inadequate. It seems to us, on this side of the court, reading this case, that sometimes when Lord Hailsham refers to compensatory damages, he actually means what I'm calling general damages and aggravated damages.
Yeah, well, aggravated damages are conventionally regarded as purely compensatory.
Precisely, absolutely.
But they compensate a different interest.
Exactly.
Injury to feelings, which is not the core interest which the tort protects.
Absolutely, and I'm not suggesting Lord Hailsham was wrong on that.
No.
One of the problems here is
emphasising it by way of distinction from exemplaries. Yeah.
Exactly. Sometimes aggravated gets confused with exemplary.
Well,
we all know the problem.
Quite a lot.
Exactly. Well, what is odd about this case, if I can put this very respectfully, is that at one point Lord Hailsham said it's very important to get the terms right, and then later on it's not always clear that he does. Let me just put it as loosely as that. So, having held that the jury direction was just about okay, the second aspect of the ratio is that in both exemplary and aggravated damages, the sum awarded must represent the highest common factor which is relevant. That's at 1063 G to H. Then, at 1065 C, Lord Hailsham goes on to discuss whether the award itself was excessive. And at 1067 D to E, he says these considerations really conclude the result of this appeal. Lest other litigants be put to expense and uncertainty, it's unavoidable I should now deal at length with the wider issues. In other words, what follows is obiter. But it's obiter of the House of Lords, but it's obiter. At 1070, there's a heading, the subjective element in damages, and of course the court will in due course look at this passage, in particular the passage which the council teams have highlighted for consideration. Now, I'm not going to read it out, but the key passage, I suggest, is at 1071 to 1072. That's really the key passage. And at 1071 A to D, we respectfully say that that mirrors our general submission about what compensation is in this type of case. And then at 1071E, the Lord Hailsham talks about the factors that go to aggravated damages, and between F to G, the true relevance of claimant's conduct, i.e. provocation of libel or a libel in response. Nothing about claimant's post-publication conduct, certainly nothing about claimant's litigation misconduct. And in the course of that discussion, my lords see the citation from Lord Isha in Trade or Pride and Graham, and I'm sure the court has picked this up, but the parentheses in the quote are the parentheses of Lord Isha, not Lord Hailsham. That makes a legal point about the defendant's conduct, but of course not about the claimant's conduct. By including the parentheses in the quote, it can't be surmised from that parentheses, even in an obiter rather than part of the ratio, that claimant's litigation misconduct, or conduct leading up to the trial of the action, is relevant to general damages which are compensatory in nature. And therefore we see that that quote, and in the parentheses I would personally add "and of the plaintiff," is not in our submission a support for saying, oh well, all of claimant's conduct is now in, including litigation misconduct. That's certainly not what this case was talking about, not what Lord Isha was focusing on.
You said that that was, the parentheses are from Lord Isha. I must confess that when I first read this, I had taken it to be parentheses of Lord Hailsham. But that's wrong, is it?
I had as well. My learned juniors checked it up. He said he told me he checked it up, and that's what he told me the position was. We will check it again.
It's odd because the quotation marks would and parentheses would suggest that it's Lord Hailsham's.
I'd also read it. To be totally fair, I'd also read it as Lord Hailsham. Indeed, when I settled the appeal notice and the skeleton, although I didn't say that in terms, I accept that's the way it reads, and that was the way it was intended to read.
But
so,
it doesn't really matter, because Lord Hailsham is approving
Precisely.
whatever the proposition is. He's either advancing it or approving it.
We need to get it right.
But your point is that it doesn't really take one much further. It doesn't tell you what conduct. The problem with that is, as far as this passage is concerned, that whoever's saying it is saying that the jury in assessing damages are entitled to look at the whole conduct of the plaintiff from the time the libel was published down to the time they give their verdict. So it's very broad.
Yeah, exactly. And the problem is that the short point is, in my respectful submission, this isn't going to be the answer to the case anyway. But we do need to identify.
Well, your main point is it's all over to anyway.
It's all over to anyway.
Doesn't arise on the facts of the case.
Doesn't arise on the facts of the case, and the later cases have taken it. And it's like, and ultimately, there's a point of principle here, which is either right or wrong, which I'm inviting this court to decide, subject to the precedent point, which I know is out there and I need to come to. We'll take that under advisement. I'll come back to the court on that. Oh, you've checked. It is okay. Well, in which case, it is Lord Hailsham, and right. First impressions are right. It's Lord Hailsham. And I apologise there, saying it was Lord Hailsham. Thank you. Can we now go to Campbell and NGM, which is the decision of this court at tab 4 of the joint authorities? The claimant appeared, as the court will see at H17, I think that means sort of head note, bit 17. The claimant appeared as litigant in person, up against the rather intimidating twin strike force of Mr. Caldecott QC and Mr. Wilansky. At paragraph 2, the judge had given the defendant permission to appeal on damages, but the claimant's mooted appeal on damages was abandoned. It is quite if I may put it this way, it's quite a remarkable appeal, not least because the Court of Appeal decided, in this case, that it could find as a fact dishonesty, which had not been found by the trial judge without hearing all evidence on the point, so as to reverse the result and allow the appeal. See at 105, 107 and 115. But, I mean, that's not the reason why I'm saying it's wrong. At paragraph 4, the court will see there were a number of allegations. A, B and C couldn't be justified. The major issue was whether D and E could be justified to diminish damages on a partial truth basis. At 6 to 7, the claimant went further and sought an enhanced award, alleging that the defendant had doctored what was called the first video to become the bobber video. Conversely, he provided the Duffy video, which he said was the undoctored version, but which, if the claimant's allegation was false, might have suggested that the claimant had doctored a video and presented false evidence himself. See paragraphs 10 and 11 for the defendant's case on this point. So that was the he said in this case, and the court will also see between 14 and 16 this was far from a simple trial for the trial judge to deal with, not least because the claimant was acting in person. I mean, that comes through pretty clearly. Against that rather odd background, we come to the legal reasoning, starting at 27. We're not concerned with special damages or punitive exemplary damages, only with general or aggravated compensatory damages. And that's what the case is dealing with. Now, let me go back and start then at paragraph 8. At paragraph 8, the court sets out the legal principles which govern libel damages in this case. And they say they're going to come back to 21 to 35. But it's common ground, they say at 8, that 3 elements of a defendant's conduct could increase damages. All of that's correct. That would normally sound in aggravated damages, not general damages. As to paragraph 9, on one reading, this paragraph would be correct. If it's saying that the defendant's conduct relevant, because the defendant's conduct can be relevant to aggravated damages, so a claimant's conduct may be relevant to disallow aggravated damages, that would probably be unobjectionable. But if it's read to mean that, more broadly, to mean that a claimant could have general damages reduced for litigation misconduct, then that's wrong for the reasons we've set out on this appeal.
I was reading this this morning again and wondered whether, or Justice Schumann was saying that it was common ground. This was the position. What's your submission about that?
Well, of course, it's very tempting for me to say yes, it is, and it follows on from paragraph 8.
Seems unlikely with the counsel involved.
It's just not
the positions that they were trying to defend.
Yeah, it's just not clear.
Yeah,
it
isn't clear.
It's just not clear. I mean,
There's no other indication, is what I was really asking.
Yeah, I don't want to put my case too high.
We have what's there. I just wondered whether there was some other indication one way or the other.
No. And if we then come on to where he comes back, where the court comes back to this point at paragraph 26, of course, what's interesting about 26 is that litigation misconduct is not included in either point 3 or point 4. And then turning through the case, which I appreciate the court will have read, 29, with respect, is Wright, general bad reputation is considered earlier. 30 refers to Chamberlain, but that's a partial truth point, which is a point I've referred to earlier. That's distinct from claimant's conduct. And that distinction actually is identified clearly at, we submit at 32. And 32 is really the main point of principle. And we say this correctly draws a distinction between partial truth cases like Chamberlain and, quote, wholly disreputable conduct which was established in the course of determining the issues in the litigation itself, those quotes. That is an important distinction. The misdirection of the court is in asking the wrong question of whether litigation misconduct is relevant, and answering it, we've no doubt that such conduct is relevant, and here it is of the utmost importance. The issue of relevance is actually mentioned, I think, 3 times in the part of paragraph 32 before the quote from Broome. But what is not asked is relevant to what? And that's really important, because independently of partial truth, it's not even arguably relevant to the actual injury to the claimant's reputation in relation to the defamatory allegation at all. The allegation here was that he was a paedophile. Litigation misconduct is doctoring evidence and suborning perjury. It's not even in the same sector of his reputation. Litigation misconduct is, of course, absolutely relevant to any discretionary decisions the court may make. I've made that before. But not relevant to general damages, which is a matter of obligation and not discretion. Against that background, 33 is what the Americans would call a conclusory statement. And we now know that the answer to an, quote, affront to justice, quote, case, is that if it's a really exceptional case, you can strike out. I touched on that point earlier, see the Supreme Court in summons. And we do submit that the conclusion in 33 doesn't follow from the passage cited in Broome, because the examples of claimant's conduct in Broome are all about conduct prior to the litigation. That's the point I made in my written argument I've already touched on. Now, had this court in 32 and 33 confined its reasoning to saying that because defendant misconduct conveys damages, which sounds an aggravated damages, then claimant misconduct can reduce or disallow aggravated damages. If it was limited to that, that would be unobjectionable. The critical point is that they stray into general damages and defend the restitutio principle. 34 to 35 doesn't grapple, we say, with the question of whether what was said in 33 is in fact consistent with, quote, the general aim of libel damages, close quote. Now, as to the disposal of this case, and the court will appreciate that one point I made in writing is, even in this case, he wasn't sent away with £1. I mean, the court will appreciate that's a very secondary point. I mean, I haven't come here, so to speak, to argue about the difference between sort of £1 and £20,000. My main point is going to be, if I'm right, I should get £100,000 or something very close to it. But let me just show the court what happened here. When the court looks at 117 to 119, the court will see that had the libel been made good in full, it would have been near to the top of the range. I think then it was about £250,000. The partial truth point meant that the damages, and this is in 118, wouldn't exceed £100,000, but the litigation misconduct knocks him down to £30,000. It's still £29,999 better than one, but that even in this case, he didn't get what I would call nominal, in the sense of purely nominal. Not a lot, but 30 is not nominal. Now, there were 2 later cases, and this case, where this Campbell principle, if I can put it that way, has been applied either expressly or implicitly. And we say both are wrongly decided for reasons essentially which I've already submitted. But let me take my lords and my lady to the cases. Would the court just give me one moment? So Joseph and Spiller, and I'll take these relatively quickly because if I'm right on the point, they're first instance decisions, and I say that with greatest respect to the judges. Joseph and Spiller is at tab 7. I'll give my lords and my lady the references. At 168 to 170, partial truth is established, but the claimant succeeds on 2 allegations. The points at 171 to 173 are right about post-publication conduct being irrelevant to partial truth. 174, we submit, is right on evidence properly before the court. This is pre-Deere, if I can put it that way, so without the Nicklin extension. 175, as I said earlier, the litigation dishonesty was in part admitted by the claimant in his fourth witness statement. And the argument at 176 is based on deceiving the court throughout the proceedings. It's interesting, there was no argument advanced to the contrary. Indeed, it seems to be the claimant's counsel who proposes nominal damages as an available outcome. And at 177, it's clear in my submission that it's on the basis of abuse of process. He actually cites Fairclough and Summers that he awards nominal damages, even though that authority doesn't actually talk about reducing damages. It talks about striking out the claim. And the reference to Summers at paragraph 41 is to the discussion of the CPR strikeout. Now, the judge is obviously right to refuse the claim for special damages, but he's wrong to say this leads to nominal damages overall. And we do say, with respect, that in 178, there's no real reasoning there, other than to say the judgment itself provides sufficient vindication. So that's what happened in Joseph itself. There's then a coda to Joseph in the supplemental bundle, because there's at tab 5 there's a hearing on costs. And although we saw that in the actual decision, in my submission it's clear, he cites Summers, the basis of the decision appears to be abuse of process. At 4 to 6 in the cost judgment, for some reason it's not easily apparent why this was relevant on costs. An alternative basis for nominal damages is advanced, based on grovelar, which is par excellence, a partial truth case, the familiar, by now familiar obiter in Broome, and those dicta as we say, misinterpreted by the court in Campbell. And here it's at 6, he specifically relies at Campbell to reduce general damages beyond partial truth to penalise litigation misconduct. And he then at 10 to 16 suggests Summers as an alternative route to nominal damages, and saying that the abuse of strikeout for abuse of process was an alternative route, and if the dishonesty had been discovered before trial, he would have actually done so. And of course, if he'd wanted to follow Summers, he could have struck out the case after trial by now. So it's a little bit odd, I say with respect, to say, well, if I'd known this before trial, I would have struck it out. I mean, you could do it after trial if it was a truly exceptional case. But what he couldn't do, in my submission, was to reduce general damages. Now, the second case is Fly Me Now, which, given that my Lord Justice Warby decided this, it's probably going to test my abilities as an advocate.
You don't need to use the word respect, it's right.
To breaking point. I'm grateful. The claimant here was a company.
So which tab is this?
Oh, so, I'm so sorry, it's tab 9 of the Joint Authorities.
Thank you very much.
The claimant is a company. Now that affects both whether Article 8 is engaged, but also affects the damages recoverable. Companies can't get aggravated damages, will often get lower general damages because it doesn't really have feelings to be injured. At 5, the action is commenced prior to the 2013 Act, so defences of justification and qualified privilege were tried alongside meaning and malice. In 6, the claimant's conduct in misleading the defendant leading to publication is, as I submitted earlier, that's very close to contributory negligence conduct in personal injury PSLA, and that's pleaded in substance, if not in form, as an abuse of process defence. And 7, my Lord sets out 2 limited issues, which I won't read, but the court will see what the issues are. And if we jump forward then to the discussion of this case, and if I can take the court to 89, please, on 283, I think, of the bundle. The litigation dishonesty by the claimant was live at the time of trial. Contrast with between 94 and 96, dishonest and disputable conduct to the defendant prior to publication. Those two issues were there.
Sorry, what was the first issue?
The litigation dishonesty by the claimant was live at the time.
Yeah.
108 to 112, the defence of justification failed, but partial truth was relevant to damages. I've explained why earlier. 121 is where we have the heading abuse of process, considered and rejected. This isn't a case where the claimant brought the libel on himself. And then at 125, under the heading damages, there's a discussion which the court will obviously have read and will no doubt reread. And we respectfully agree with the claimant's conduct as a contribution to injury. We also agree with 1, partial truth, and 2, dishonest behaviour, but not with 3, litigation misconduct, which is importantly to be distinguished from the behaviour. We therefore agree with what is said at 126, and we agree also with what is said at 127. The fobbing off is clearly relevant under Chamberlain and Burstein, and the same point comes back at 129. So the only point we would disagree with is the litigation misconduct point, relying on Joseph or following Joseph and Spiller at 128. Now, the learned judge gave £10. Whether that £10 could and would have been awarded, even if you strip out the litigation misconduct, of course, I can't make any submissions on that. But what I can say is that one could see how you could actually reach the same result if you stripped out the litigation misconduct. In this case, you could.
Can I just ask you about paragraph 128?
Yes.
Because that on your submission is really the critical paragraph. Now, my lord, when sitting as the judge there, did say in the 4th line, he has given false evidence, and as I find, continued to stand by the original case after he realised that it was false. Those two are disreputable facts that are properly before the court. Do you take issue with that description of what was before the court?
Well, I don't wish to split hairs, but actually it's important to split some hairs here.
Mm-hmm.
Of course it's a fact in the sense that my lord made that finding a fact.
Yes.
The question is whether it's evidence for the purpose of the relevant principle. I know that sounds terribly splitting hairs, but it is, in my submission, an important distinction.
No, I agree. That's why I asked you the question.
Yeah.
So you're saying, I think, that there can be a scenario where a trial judge makes findings of fact, but which are nevertheless not evidence for the relevant purpose.
For the relevant purpose, exactly. And that's really important because I don't want this court to think that I'm submitting, well, the trial judge can make findings and sort of so what. Of course, they can be really relevant to all sorts of other things. The question is relevant to what? That's why I picked up in the previous author, in Campbell,
Yes.
the constant reference to relevant. But one always has to ask relevant to what? Or in what context? I mean, I can rephrase the question, but the court knows what I'm submitting.
Yes.
So to come then to this case, and I'll go to the judgment here fairly quickly, and then I do need to leave just a bit of time, obviously, to deal with the precedent point, because that's an important point. But I will certainly, I may not leave myself much time for reply, but I certainly will finish before the short adjournment, so I don't cut into the learned frenzy.
Thank you.
If I can go to the judgment in this case, which is at core, the joint authority, I was right, core 6. And again, I'm going to do this fairly quickly because the court will have read it and will reread it. And because this point really is a point of principle, so to speak, I'm either right or I'm wrong, so to speak, and we can read what the learned judge said. But the way we put it is this: 141. I'm just picking it up here under the heading relief.
Yes.
141 is unobjectionable. 142, the first two sentences are obviously correct, although this wasn't and couldn't have been a general bad reputation case. The error creeps in, really, by reference to Gatley at 34096. Because as I've shown the court, in our submission, that misses the nuance of Mr. Justice Nicklin in Deere, and indeed what Gatley said earlier on. And the citation by, what's interesting is that the learned judge here cites the particular bits of Deere and Bockover which are cited in Gatley, and doesn't go back to remind himself of the earlier bits in Deere. In 143, there are 3 sentences. The first sentence is a statement. I don't think anything is objectionable there. The second is a finding of fact that more than minimal damages would have been appropriate for 15 allegations of fraud, I think actually 16, all but 1 at Chase level 1. Now, I'm obviously not taking issue with the fact that more than minimal damages will be appropriate, but with respect, that's putting it a bit low. I mean, this is a pretty serious libel. But anyway, the next sentence, the judge is entitled to disbelieve my client's evidence of distress. So no compensation is given for distress, and he's entitled to mitigate because he says the defendant was goaded. Again, my client respectfully doesn't agree, but I can't challenge the findings of fact. 144 to 147 are, in our submission, a repetition, really, of the error in Joseph and Spiller, and the single paragraph where we say there's error in Fly Me Now in 146, you'll see that 128 is referred to. And that in itself is traceable back to the Court of Appeal in Campbell. So I hope now that the court sees, so to speak, how the learned judge approached it, the court will see how that ties in to my submissions. And if my submissions are right, then in my spectral submission, the judge's approach was wrong. Of course, if the court is against me, the learned judge was right.
But as I read his judgment, the trial judge is actually making 2 points. And we see this most clearly at paragraph 144. The first point he's making is that although he has made a finding of fact that there was serious harm, see paragraph 143, first proposition is the deliberately false case on serious harm requires a reduction in the award of damages. That's the first thing he's doing. So some reduction.
Yeah.
But he's then saying, point 2, in the final sentence, it would be unconscionable for the claimant to receive any more than nominal damages. And analytically, it might be said those are actually 2 distinct propositions, but he is making both of them, isn't he?
He is making both of them. He seems to say, well, you can read this in 2 ways, I accept. You can either say it's 2 completely distinct propositions, or you could say the first proposition is I can, so to speak, get into the territory of reduction, and actually, once I look in the territory of reduction, I'm actually down to the bottom of nominal.
Yes.
That would be a way of reading it, not as 2 completely distinct points, but the second flowing from the first.
I understand. You may be right, but I think your fundamental submission on this appeal is that it's inconsistent with both principle and authority even to embark on the process of reduction, because having found serious harm, the task of the court then is to evaluate, so far as the court can ever do this, how in monetary terms that harm is to be compensated.
Exactly.
And you may, if you find that a man's a liar in court, there may be other steps you might take. Costs on an indemnity basis was indeed one of those.
Yeah.
But I think your fundamental submission is that even, never mind unconscionability reducing it to £1, that even to reduce it at all was wrong in principle. Is that right?
It is, and again, to be totally frank, and perhaps sort of break the advocate's fourth wall, if I can put it this way, it would be very tempting on an appeal like this to say to the court, well, look, throw 50,000 our way. But I can't really, because I'm either right given these libels, you know, I'm either right and, okay, I've got a limit of 100,000 in the claim form. If I hadn't limited it, so if it hadn't been limited, and there's the England and Wales point, but just looking at it sort of in extenso, it's right, I'm going to be submitting in a moment, right at the top end. So, my Lord, with respect, is right. I'm either right at £100,000 or very close to it, or I'm at £1 or £10 or, you know, right at the nominal damages. It's forensically tempting, but I think intellectually impermissible for me to say, well, let's sort of do a judgment of Solomon.
That's very fair.
Now, can I continue from that last point and just make the point that there's no partial truth issue on the facts of this case? Because, as I've said, we submit there's a common basis for those 4 categories of evidence as being theoretically permissible under the restitutio principle, stripping out litigation misconduct. And when it comes to partial truth, as I said earlier, what I mean is, although the justification, the truth defence has failed, the defendant has established some facts and some truth, therefore, in what was said in the natural and ordinary meaning found by the court. Partial truth does operate to reduce general damages properly because restitutio does not require compensation for a reputation that a claimant is not entitled to. And again, I think also here now coming back, reiterating part of my answer to my Lord's point earlier. So a person who defeats a truth defence on an allegation of murder, it turns out he wasn't a murderer, but what he did was grossly negligent manslaughter, it's still been established that he unlawfully and culpably killed a person. And the partial truth of the sting will reduce the general damage. Similarly, to take an example from the authorities, and one certainly closer to my home, a goalie who doesn't actually throw football matches but by letting goals in, but does make the corrupt agreements to fix those games, may find his damages are significantly reduced. Sequel.
It wasn't actually established that he didn't throw matches, or rather that it was not proved that he did.
Yes, I think that may...
Was there evidence?
Was there evidence? Well, absolutely. I mean, the Grobbelaar case is an odd case.
Unfortunately, we don't have to decide that case.
Exactly, for all sorts of reasons. And I think we should call full time on the Grobbelaar case and not reopen that one. Now, applying that principle to this case, the starting point, as I've said, no substantive defences remained. None of the issues related to the overseas conference cases, which my client had also dropped before trial, was actually pleaded. And so the judge's findings that I've submitted go nowhere to prove any part of the truth of the meaning of the defamatory allegations, which was that he'd promoted a fraudulent claim to be Satoshi Nakamoto. Now, what you can't do is say, well, because there's an allegation of dishonesty, and I've shown dishonesty somewhere over here, well, that sort of cuts across over here. There are rules, as the court knows in this area, as to the proximity, the relationship between what is shown. And notwithstanding that the sting of the libel is fraud, there is in my submission a qualitative difference, a fundamental difference in degree between a claim that someone is lying about the most significant biographical detail in their entire life, which is of immense significance to the world at large, and any other lie that they may happen to tell. But if you falsely accuse somebody of fraudulently claiming to be the heir to some obscure fallen European throne, you don't establish a partial truth because you've shown that they lied about a speeding ticket. Or any other lies. Lies are in the news this morning, but we'll leave out other sorts of untruths. The libel in this case was not just, you've told a common and garden lie. It's really hard to express for my client just how personal this lie is. It goes to the heart of his being, whether he was lying about being Satoshi Nakamoto. That is the most serious of defamation claims. It's a matter of profound biographical significance to him. And one can put it this way: when, I hope after many years, my client passes on, whether he was or was not the inventor of Bitcoin is likely to be the first line in any obituary written about him. I mean, it really goes absolutely to the heart of who he is. And against that background, the court will appreciate that, we do say, as I said a moment ago, that £100,000 would be the minimum, so to speak. In other words, a maximum claim should be the minimum awarded for this action. Now, I've left myself, I hope, enough time to deal now with the third part of my submissions, which is a doctrine of precedent. And, of course, this point was raised quite properly by the learned judge. It was also highlighted by my Lord Justice Warby on the permission issue, and I need to deal with it. Our submission is that the court is not prevented from giving the relief which we seek by operation of the doctrine of precedent for two reasons. First, because the point was assumed and not argued in Campbell, and because of that, it's not binding on a subsequent court of appeal at all. Second, and of course these are independent ones. Second, even if Campbell would otherwise be binding, it's inconsistent with the later court of appeal decision in Al-Haq, and by that I mean the first holding, which wasn't overturned in Summers, or it's inconsistent with Summers, essentially the same point. And for these purposes, I don't think it matters for the precedent argument which of those heads of the second point is right. Actually, if one's right, they're both right, I think. Now, let me take the first point, the point not argued. The question as to whether the Court of Appeal has to follow its previous decision if the point wasn't argued has come before the court in a number of cases. One of them is a case in which I appeared. That's why I'm afraid I've taken the court to this one. I happen to know about it. It's the FSHC case, which the court is likely to know on a different point. This is now the leading case on rectification and the judgment of Lord Justice Leggett. I think that's why it's generally cited. But the learned judge, Lord Justice, as he then was.
Sorry, which tab are we in?
I'm sorry, it's tab 10. I didn't say, sorry. It's tab 10 of the main authorities.
Thank you very much.
One of the issues we'll see that we come to is that I was submitting, well, let me show the court the paragraph. At paragraph 49, there's the chestnut point in this area of the law, which is it objective or subjective, if I can put it that way. And I made the usual unhelpful submission from counsel's row that, well, it doesn't really matter, I win either way, which Lord Justice Leggett thought, well, you know what, let's have a look at this in a little more detail. That's why you get to, at some point, yes, about 6 lines down, when invited to make clear, however, and to push me off the fence, whether or not he accepted that on a correct understanding it's objective, I said no, and I said it's subjective. And without getting into the issues, I was essentially submitting rectification is all about, there's got to be some sort of moral type reason that enables the court to interfere. What you thought you were signing isn't what you actually, what you signed isn't what you actually thought you were signing. And I also pointed out there, and the reason why I go to this paragraph is I referred to Brit Oil. And Brit Oil was a case of binding authority on this court. And of course, some of the other cases in this area, in particular Chartbrook, were Obiter, and there were other cases, Daventry, which bedeviled this area as well. And if we turn through this rather long judgment to 133, there's a heading, the need for reconsideration. And I don't want to get into the interstices of the rectification point, but the court will see that there's a discussion there as to whether they're bound, what's Obiter, Chartbrook, Daventry, Jocelyn and Nissen. I mean, all this was very well trodden authority. There was lots of academic writing, of course, as well. And then at 135, on the question whether halfway through, whether binding precedent has been created, the members of the Court of Appeal express themselves attracted by a suggestion that the conceded point of law should be open to argument in the case, provided it was made plain it wouldn't apply where an argument, though put forward, had been weakly or inexpertly put forward. And then 136 I rely on. And 136, in my submission, makes the point that the court is not bound by a proposition which wasn't argued in an earlier case, even if part of the ratio. Now, given the time, can I respectfully invite the court will see at the end of 136 as a reference to Rawlinson, in paragraph 43 of Rawlinson. Could I respectfully invite the court to take that up later? And when the court sees that and reads in particular the citation there from Kadim, which is also relevant on this point.
Yes. Can I just mention for both counsels, assistants, I hope, but it may not be, like you, I remember cases that I was in, and I gave a judgment in a case called Jazztel. Jazztel. It's a tax case. I think it's last year. And I gave a concurring judgment, which is on this point, about the effect of a concession in an earlier case and whether it binds this court. It may not be of any further assistance to either side, but because I remember it, and I did say something about this point, you may just want to look at it over the short adjournment.
My Lord, I'm grateful. Thank you. So, against that, it's the point really which my Lord Justice Warby raised with me a moment ago, which is we submit, based on Campbell 8 and 9, that short interchange we had, we submit that it's far from clear whether it was argued at all. I accept if it was argued but argued badly, the principle doesn't apply.
Well, that's what I said in Jazztel.
Oh, right. Well, in which case...
Yeah. Just to sort of illuminate on this point, what I said in Jazztel was that if something was argued, then it's still binding on us. But that doesn't mean that if an issue was never argued, and I gave an example of that, it may or may not be helpful, which is why I'm asking for counsel's assistance on this point. I made reference to a decision of this court, I think back in 2007, called Elias. And in Elias, this court completely reopened the very issue, the very outcome of an earlier decision in 2002, I think, called Ab Cipher. I don't want to distract you for too long, but the point essentially that I made, right or wrong, in Jazztel was that if an issue was not previously argued, then the decision is not binding. But if the issue was before the court, but the particular submission wasn't made, which is now being made, well, that's just too bad. It's still binding on us. You may just want to reflect on that.
Yes.
Over the short adjournment.
My immediate reaction is that it may depend, so to speak, on the fact. And so
Yes.
there can be cases where, because a submission wasn't made, that particular point wasn't argued. It may depend on how you define the issue or the point.
Exactly. Yeah. But it'll become clearer if you look at Jazztel. I don't want to take up your time.
No, and I'm conscious that I do need to finish.
Yes.
So the court has what I said on 8 and 9 in Campbell. The court will reread it. We submit there's no recording of legal argument or even reasons given for the converse of paragraph 8 being correct. It seems to have been assumed to be true. It may have been part, as I said, of the common ground. There's certainly no reading that that proposition was argued. It doesn't appear from the reading that the proposition was argued. It's really given as axiomatic that that's the case. And we do therefore submit that the approach at 4 Seasons at 136 applies. That's that's sort of route 1, I can put it that way.
Yeah.
And if I'm right about that...
Now, do you say that 4 Seasons is binding on this court, for this proposition?
Well, Lord, it is, yes. Yes, it is. And the point was certainly argued in 4 Seasons. But again, to be fair, well, perhaps not to be fair, just to perhaps make the point more strongly, the citation in 4 Seasons for the proposition anyway. So I'm not really sure that Lord Justice Leggett there was actually saying anything very much new. I think he was really distilling and perhaps clarifying, if I can say respectfully, what was already in the authorities. But insofar as it is new, that point is binding. The second route for me on the precedent point is, I think I said earlier, it's an either, it's two independent routes. I think I should probably say fairly, they're probably alternatives, because I think the second route accepts that Campbell is otherwise binding, but I think probably technically it's alternative to the first one, but it may not matter too much. If the court considers that the point was argued in Campbell, so it's capable of being binding, then we say that two of the exceptions in Young and Bristol Aeroplane apply. Now, the court will, I hope, forgive me for not taking the court back to Young and Bristol Aeroplane. The court well knows, I mean, it's back in 1944, but it's still broadly applicable. Just to give the court the reference, it's in the authorities at tab 1. The classic statement of principle is at pages 729 to 730, and we say that exceptions 1 and 2 apply. Now, of course, there, I can have either exception, but I do say 1 and 2 apply. And essentially, we say this, that Summers, as we've seen, overturned Al-Haq, but only on the second holding. The first holding in Al-Haq, i.e. the fundamental principles of compensatory damages, survives, and indeed we say is approved by the Supreme Court in Summers. So, putting it in terms of the exceptions in Young and Bristol Aeroplane, so far as exception 1 is concerned, we say the Court of Appeal decision in Campbell can't stand with the remaining part of the decision in the later case of Al-Haq, which decided a litigant's conduct is an inappropriate basis on which to reduce compensatory damages, which is what the court had done in Campbell.
Well, Wilson, I'm sorry to take up your limited time, but isn't the contrary the case? Because unless the Supreme Court, you're right about the Supreme Court upholding the bit in Al-Haq, then Al-Haq is the later authority, and it's inconsistent with Campbell, and therefore Al-Haq is per incuriam, Campbell is the one we should follow.
But I'm not using the language of per incuriam. I'm just going back to Young and Bristol Aeroplane, where a court is faced with two conflicting decisions.
Yes, but if you're faced with two conflicting decisions, and the second one is in conflict with the first, you follow the first.
Well, in my respectful submission, the court is entitled, in those circumstances, to follow the second, because when there are two conflicting decisions, the court, in my respectful submission, can choose. I accept that the court may choose, because unless the second one is per incuriam, it's a case of conflicting decisions, not a per incuriam. So the second decision doesn't, so to speak, fall away. And in my submission, once you have conflicting decisions, the court can decide which path to take. It may not be relevant in this case ultimately, because as my lady says, once we get into Summers, and that's why
about the Supreme Court, that's a different.
And that's why I brought Summers into the argument, because again, with breaching the fourth wall, this is the point which I thought of, and I thought, well, actually, it is an interesting point. I know when counsel say interesting, they normally mean expensive, but it is an interesting point. But because I've got Summers, I don't need it, because if I'm right on this point as a matter of principle, and I run it through Summers, then I get a Supreme Court authority which trumps.
Well, there is another difficulty, I think.
I'm sorry, I didn't hear.
There is another possible difficulty with this line of argument, which is an analysis of Al-Haq that says it's only authority for the proposition that there is no general rule of law that you reduce damages on account of litigation misconduct. That's quite a limited proposition. It doesn't exclude the possibility of one exception beyond the insurance exception, namely defamation, which wasn't the subject of any argument in Al-Haq. So we get into quite deep waters.
I accept that one could try to do that. I think that would be, I think it would be an unfair reading of Al-Haq. The statements in Al-Haq are pretty clear, in my submission, as statements of principle. And certainly when one comes to Summers, it's very clear as to what the principles are. I mean, Summers, in my respectful submission, makes it absolutely clear which tools in the judicial toolbox can be used to reduce damages and which can't.
The difficulty with common law reasoning is that it's not legislation. So even the Supreme Court, with the greatest of respect, isn't legislating. It's not, as it were, setting out a code of this is the law of the land. Again, as I said in Jazz Tell, and again, I may be wrong, the ratio of any case is the principle of law which is necessary to explain the outcome of that case on its facts. Now, query whether in Summers, although of course we look at the general statements and they say these are the general tools that are available, etc., etc. We understand all that. We take on board all it. But I query whether all of that can be said to be part of the ratio of Summers.
In my respectful submission, it is for the purposes which I'm looking at,
Yes.
i.e. precedent. And that's not meant to be a dodge of my Lord's question.
No.
What is ratio and what isn't ratio? I mean, I remember standing in this court on a previous occasion having quite a tussle with a previous court on whether something was or was not ratio. I mean, it's very hard sometimes to identify what's ratio and what's not.
Indeed.
When one looks at it through the prism of precedents, I think one then really asking the question, is the court setting out something which it expects other courts to follow and should follow? And I appreciate I've dodged my Lord's point a little bit, but I'm hoping I'm giving a response to it which is relevant for this case.
You are, that's helpful.
The other point I would respectfully make is that when my Lord contrasts judicial decisions with legislation and the precision thereof and how they're put together, it may be like sausages that it's best not always to see quite how legislation is put together.
I think Bismarck said that.
So my Lord may be doing the courts a little bit of an injustice, and maybe I'm doing the courts of Parliament a bit of an injustice as well. But anyway, so that's the second. That's my second route.
Right.
Two very final points.
Yes.
I accept, of course, if I have persuaded the court on neither of those two, well, neither on my route 1 nor on my route 2, A and B, then of course the court has to refuse the appeal, of course.
Dismiss the appeal.
Dismiss the appeal. We would invite the court to give permission to appeal to the Supreme Court, and, as I said earlier, to give the Supreme Court a reasoned judgment. But of course, there I'm straying well into the discretion of the court. Finally, if the appeal is allowed, we don't seek a remission to the judge or a new judge. We'd invite the court to remake the damages order. I've made submissions en passant about that. We would also then obviously have to look at the costs question, or we would invite the court to hear us on costs, because we would then become the successful party. Of course, consistently with all of my submissions, I'm not submitting that it would necessarily follow that the cost order below would be overturned, but all I'm submitting is that we should be able to have an opportunity to make submissions on it. My lords, my lady, unless I can assist the court further, those are our submissions.
May I just check if my lady or my lord hasn't? No, that's been very helpful, Lord Wolston. And Miss Evans, we look forward to hearing you at 2 o'clock.